Okay, Sunday morning, October 13th. We still have not heard one peep out of child support or the Assistant Attorney General. That is the one protecting child support here in Utah. A couple weeks ago, on the 1st of October, we filled out our motion for summary judgment because they failed to respond. And now we have a proposed order that I've written up this morning. Okay, again, certified mail, double click on the top here, right? And then you can go into the header, double click. And of course, we have our page numbers. You double click, right? Then you can do this and you can change it and you can bold it or not bold it, whatever. Double click and it's on all of your pages. So let's read this proposal. Okay, so first of all, in our motion for summary judgment, okay, we moved the court for summary judgment, okay? Defendant failed to respond and their silence must be construed as default, okay? Judgment for the plaintiff should be entered against the defendant and the relief requested in the complaint should be granted. Okay? So now that it's been 2 more weeks and we haven't heard a peep out of child support, okay? Once again, I'm thinking this administrative process might be the way to go. Now, just for the record, too, I don't know if these guys have called each other and if everybody is, scrambling, or if the court is going to say, well, we don't really do those anymore, or, the appellate court said this, or I don't know. But it's been another 2 weeks, okay? It's been exactly 2 weeks. So I'm going to throw in a proposed order, okay? In my motion, remember this is just a 2-pager, okay? Their silence is construed as default. I waited, okay, and they didn't, he put in that one piece of paper that said that he needed an extension of time. Okay, well, so that you got the paperwork, but if you don't have a claim, then what are you going to do? Okay, so nothing. So it says here, plaintiff would write a proposed order upon request, respectfully submitted, blah, 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 blah. Here's my certificate of service. Okay. So all this went to the court on the 1st. And now we're going to look at our proposed order. So this is not like written in stone, and I've never done one of these before. So I actually went and looked at some court cases and kind of pick and choose a few lines from, cut and pasted. And so let's go through this real quick. So we have the date, we have all this stuff. Remember, you can make all this stuff look the same, okay, by going in there and just cutting and pasting all this stuff onto another page, right? Make it all look nice. Everything's nice. You got your little boxes you put in there, right? So make it all look the same. It's Judge D. Benson. Okay, so let's read this. What did we put? This matter is before the court on plaintiff's amended complaint, bill in equity. We have considered, now you're going to have to do this in, like she's writing it, right? So we, the court, have considered the papers filed in support of the plaintiff's amended complaint, and after defendant's failure to respond in the allotted time, we deem the motion, you know what, let's change that. We rule, we rule the motion for summary judgment appropriate. You know what, I don't like that either. Hang on a second. We rule the motion for summary judgment appropriate for resolution without oral. Okay, so you know what? Yeah, let's keep it. We rule the motion for summary judgment appropriate for resolution without oral argument. Okay, so basically they're ruling that there's no facts in controversy and there is no need for oral argument. Okay, so defendant has proffered no explanation for their failure to answer the complaint. We find that the defendant's culpable conduct led to the default. In the Ninth Circuit, okay, and I'm going to quote this case right here, Franchise Holding 2, that if a defendant has received actual or constructive notice of the filing, which they did, right, because they answered with a, hey, we need more time, right, of the action and failed to answer, its conduct is culpable. So what is culpable? So we jump over to DuckDuckGo and we look up culpable, guilty, criminal, meriting condemnation or blame, especially as wrong or harmful, negligence, the defendant is culpable for her actions. Okay, legaldictionary.com. The connotation of the term is fault rather than malice or a guilty purpose. It has limited significance in criminal law, except in cases of reckless homicide in which a person acts negligently or demonstrates a reckless blah, 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 blah. In general, however, culpability has milder connotations. Okay? Free Dictionary, deserving blame or being wrong or evil or injurious. Blameworthy, right? Blamable, blameable, blamable. That looks like blamable. Blameful, blameworthy. Okay. So basically, you are guilty. Anyway, that's what I do when I don't know a word. Okay. Please, people, don't use words that you don't know what they mean. Okay. So we find that the defendant's culpable conduct led to the default. In the Ninth Circuit, if a defendant has received actual or constructive notice, which they have, and failed to answer, its conduct is culpable. Okay? And there's defendant have also failed to assert a meritorious defense that would justify setting aside the default. Therefore, summary judgment for the plaintiff is granted. Okay? We affirm that there are no facts in controversy. Remember, that's important, man, because if there's no facts in controversy and it's already been adjudicated in your administrative process, it's already been decided. They defaulted, they have no claim, and by their silence, they agreed to the new terms of the contract, right? Okay. So we affirm that there are no facts in controversy and that summary judgment for the plaintiff is granted. Okay? We affirm the defendant's conduct led to the default. The plaintiff has a claim, and where timely relief is sought, doubt, if any, should be resolved in favor of the plaintiff so that cases may be decided on their merits. Okay, that's basically what that means. Meritus, okay, is the merits of the case, of the claim. Okay, so page 2 here, right? Page 2. Plaintiff came to this court with clean hands and in good faith, right? Which means I'm good, right? Plaintiff requested judicial review of his administrative process and remedy. We agree with the plaintiff that the Office of Recovery Services had a duty to respond. We agree that they defaulted, and we agree that they created an estoppel, right? Remember, estoppel means you can't move forward, you have no claim, you got to stop, right? Stop. Plaintiff requested this court to find the facts and execute on the law of the contract before this honorable court. We find the plaintiff's administrative process to be a valid contract, and by silent acquiescence, the Office of Recovery Services agreed to the terms, right? Plaintiff requests the court to order defendant to pay a sum certain, 100 grand, over to plaintiff within 30 days. Plaintiff's request is hereby granted. Plaintiff requests the court to release the order of the court to Douglas Dmoomey. We all know who that is, right? It is so ordered. There's the date, okay? There's the clerk of the court's signature. There's the judge's signature. There's the seal of the court, right? Respectfully submitted. There's my certificate of service. It's going to them. It's going to this knucklehead. Okay, third party's going to sign. Certificate of service. I'll sign here. I'll sign down here, sui juris, in one's own right. So, yeah, we'll see what happens. All right, guys, peace.